hear ye, hear ye. All manner of persons having anything to bring before the honorable justices of the Supreme Court of the state of Delaware will now draw near and give their attendance. The court is now open. God save the state and the honorable court. Please be seated.
Good morning, everyone. This is a time for Judicial Watch versus University of Delaware. We'll begin with any introductions.
Yes, Your Honor. May it please the court, I am William Manning of the firm of Saul Ewing. I represent the appellee, University of Delaware. With me at council table are my partners, James Taylor and Marisa DeFeo.
Good morning.
Good morning, and may it please the court. Bill Green from Halloran, Farkas, and Kittila on behalf of appellants, Judicial Watch, and the Daily Caller News Foundation. With me at council table is Ted Kittila of my office.
Good morning.
Good morning, and may it please the court. The opinion below should be reversed because even after multiple bites at the apple, the university has still not satisfied its burden of proof to justify the denial of appellant's FOIA requests. This is the second time in this case that we're here before this court on appeal. The background facts are set forth in the court's December 6, 2021 opinion. The question is whether the supplemented affidavit of the university FOIA coordinator finally satisfies the university's statutory burden of proof for denying appellant's FOIA requests back in May of 2020. It does not. Previously, this court reversed in part and remanded for further proceedings. This court opinion clarified Delaware's FOIA law and is now routinely cited in Attorney General proceedings adjudicating FOIA requests. In relevant part, that opinion holds that unless it is clear on the face of the request that the demanded records are not subject to FOIA, the public body must search for responsive records. A description of the search and the outcome of the search must be reflected through statements made under oath, such as statements in an affidavit, in order for the public body to satisfy its burden of proof. The court went on and noted that we note that it is not clear on the face of the request for the agreement or the communication records that they are not subject to FOIA, and the university does not contend otherwise. So those are the two requests that remain at issue, the gift agreement and the communication records. The gift agreement is the agreement by which the Biden papers were donated to the university, and the communication records comprise any communications from the university about the proposed release of the Biden papers, as well as any communications between university staff and anyone representing President Biden. Now, this court was also clear that the focus is on the content of the documents. With respect to the university's FOIA obligation, the court held that, quote, a document is a public record under Section 10,002L when the content of those documents relates to the expenditure of public funds. The court clarified that the word relate means to give an account of. The supplemented affidavit was filed on July 22, 2022, and it does not satisfy the university's burden of proof for three reasons. Most importantly, it is ambiguous. Second, the university performed no search related to the requests. It reviewed no documents apart from the gift agreement, but rather relies on previous inquiries of university staff. And finally, the supplemented affidavit is largely based on hearsay. Taking those arguments in turn, the university has not given the Superior Court information sufficient to determine whether the university satisfied its burden because the supplemented affidavit is ambiguous. And starting with the communication records, rather than perform a search or review any documents, the university made a categorical determination based on information provided by two university officials that the communication records do not relate to the expenditure of public funds, and thus no documents need to be collected or reviewed. The university officials are the University Budget Director, Lionel Gilibert, and the University Vice Provost of Libraries and Museums, Trevor Dawes. Those officials provided three data points: that the university has not paid any consideration, state funds or otherwise, to Mr. Biden for the Biden papers, that the salaries of university personnel involved in the custody and the curation of the Biden papers are not paid with state funds, and that state funds are not spent on the university's email system. And that would be the email system over which emails between university personnel and anyone or any representative of Mr. Biden might have been exchanged. Now, these statements don't address whether the physical building the Biden papers are stored in is paid for with state funds, or whether the heat and electricity for the building is paid for with state funds, or a host of other potential costs related to the Biden papers that might use state funds. But that's largely beside the point. And so are the university's asserted facts, because this court ruled that the content of the documents is what is at issue in determining whether the records are subject to FOIA. Based on these data points, however, the university made its categorical determination that the communication records could not possibly relate to or give an account of the university's expenditure of state funds. And that's because the university didn't review any of the communication records, and there are no representations regarding the content of the communication records in the affidavit or anywhere else. The affidavit's even ambiguous as to whether the university concedes that any communication records even exist, as it references emails that, quote, might have been exchanged. That's on paragraph 10. So the affidavit does not say that no communication records exist. It doesn't say that the communication records exist, but we looked, and none of them relate to public funds. But here's what we do know. We know that no communication records were reviewed, and no party to the communication records was asked whether the communication records discuss how the university's custody and curation of the Biden papers would be funded. Now, the communication records, the content of the communication records, presumably contain the negotiation of the university's receipt of the Biden papers. I mean, that seems self-evident. Those negotiations would also include a discussion of how the Biden papers will be funded, because that's an essential point to a donation this large. If the communication records contemplate the use of state money to fund the university's upkeep of the Biden papers, they relate to the expenditure of public funds and are subject to FOIA. But the university has not made the search. The university's categorical determination that the records need not be searched is insufficient to carry their burden.
Counsel, in our prior decision, we stated that there was a category of documents that on their face were such that no search was required, a category of request, correct?
Yes.
So surely if the record is supplemented so that it gets the university to the same place, then there's no reason to search, correct?
Well, I don't think that's my understanding go ahead.
I'm just, you seem to be saying that if it's not on its face clear that no search is required, no amount of supplementation can get you out of a search. Is that your position?
No, that's not my position, actually. The last time we were here, actually, the court did not decide whether the university's categorical determinations were sufficient, as it had separately found that the university had not carried its burden. The position is that the supplemented affidavit is too ambiguous as to the search that was performed to actually.
So if the affidavit were sufficient to demonstrate that, together with the requests, that there were no documents subject to the search, then that is sufficient for FOIA terms. You're just saying the affidavit wasn't sufficient. But there would be no need in that case to search individual documents.
If it can be established that there's no state of the world where the content of the documents could relate to the expenditure of state funds, then I would agree that yes, that then the affidavit, then the burden would have been satisfied to justify the denial.
I understand. Thank you.
Right, but last time we were here, the court didn't decide whether the categorical determinations were sufficient. But the court did hold that, again, that the agreement and the communication records were not facially excluded from FOIA. And it went on to say, the quote, if it's not clear on the face of the request that the demanded records are not subject to FOIA, the public body must search for responsive records.
Mr. Green, I went back and watched the earlier oral argument, And I think in response to a question from then Justice Montgomery Reeves, you were asked, what is it that the university needs to do to carry its burden? So heavy emphasis on the absence of a sworn statement at that time. And you set forth a profile of what a sworn statement should look like. You said, we're looking to carry the burden of proof, the FOIA respondent should be required to submit a sworn statement based on diligent inquiry, identifying sources of information, identifying documents that were relied on. Then there's a statement about tying the facts asserted to the reasons for the denial, I think, and a statement of what capacity in what capacity the affiant is making the declaration. Is it as a witness or as an attorney? In what respects do the affidavits submitted on remand fail to meet that profile?
Well, the affidavit is a minimum requirement, as I understand the court's last opinion to hold, that essentially the affidavit's necessary, but may not in all cases be sufficient to satisfy the university's burden of proof. For example, at the university's first bite of the apple on remand, the Superior Court below found that the affidavit was provided insufficient detail to provide the court a basis on which to make its determination whether the university had satisfied its burden of proof. Here, the ambiguities in the affidavit and the categorical determinations we feel are insufficient to actually satisfy that burden. Where the sworn statements here are, we have an affidavit, but we don't believe we have enough to actually get the university over its mark.
Well, you also complain, I know you set out how you plan to argue this, but time runs short, and I'm interested in your view that essentially complains that there's hearsay. Why shouldn't hearsay be allowed in an affidavit? Your friends make analogy to 30B6 witnesses in civil proceedings, and the courts routinely rely on representations of counsel, of, who they talk to about when they look for documents. Help me understand, is it your view that there should be an affidavit from every person who was consulted in connection with the respondent's search or determination of whether responsive documents exist?
Well, under the circumstances, yes, that would help. Well, understand where the affidavit is right now. The actual source of the information is a step removed from the actual. It is not the affiant. It's not the personal knowledge of the affiant is not what's in the affidavit. It's the personal knowledge of the vice provost and the budget director. So yes, I would be asking for the affidavit to come from, or depositions of these individuals to vet the information, because again, there hasn't been an actual search. There were inquiries. There were inquiries that took place before our FOIA requests, the FOIA requests at issue were ever submitted.
Mr. Green, on that point, not to divert you further, but on the staleness point, you contend that, you point out that both of your requests were made April 30th, 2020, and the search in the inquiries in the affidavit, I believe, were done in May 2019 and January 2020. Now, they say they get a lot of these FOIA requests. We don't have to do a new inquiry every time we get one. Why is it that we should regard the supplemental affidavit as stale? with the passage of, I guess, 4 months between your request and their last inquiry?
Well, as an initial matter, it shows that the inquiries were not in response to this request, and it also shows that no actual search was performed even after this court's decision and the remand. But these are things that happened before. It shows that the university's approach didn't change, that the way the university has treated the FOIA proceedings or FOIA requests has really never changed through through the course of these proceedings or since or ever. And again, I mean, this case is about clarifying Delaware's FOIA law, about setting clear expectations for FOIA requesters and FOIA respondents. Look, the guidance that this court has provided has already made a big difference. The Attorney General now cites this case in its FOIA opinions. And the case is about making the law clearer. We've established that what the burden of proof is, and we're looking for further clarity. We're looking for a reversal and a remand so that we can take limited discovery so that the Superior Court finally has a sufficient record to determine whether the universities carried that burden.
Counsel, you don't literally mean this case is about clarifying FOIA law, do you? Aren't you interested in documents?
Well, certainly, Your Honor. We are certainly interested in getting the documents, but procedurally, where we're at now, the ball has still been in the university's court to actually make their case that as a matter of metaphysical certitude, that they don't have any documents that actually touch on the requests.
Is that the standard that the university has to meet, metaphysical certitude?
No, but
what standard do they have to meet?
Well, actually, that's a good question. No, that is actually a good question. I don't know that that's actually in the jurisprudence. It doesn't say in the statute whether this is the burden of proof is beyond a reasonable doubt or preponderance or any of the other lesser standards that we have. It's not defined. Now here, but what we're saying is that realistically, the university has had multiple bites at the apple to actually to make its case that both of the requests, neither the gift agreement nor the communication records, provide or relate to, provide an accounting of the university's expenditure of public funds.
What is the standard of proof that you are advocating as to, preponderance, clear and convincing? Do you have a preferred measure of proof?
There comes a point in legal proceedings where your opportunity to make your case comes, and if you don't make your case, typically the case is adjudicated against you. And here we are.
This is not a case where there's a box of responsive records, and we're arguing over whether someone has waived the opportunity to demonstrate that they're nonetheless not producible. This is a case where the university says there are no documents. So how can they don't deserve another bite at the apple apply here?
Well, it applies here because we're still, the university's argument is akin to perhaps saying that so there's a filing cabinet full of documents. The filing cabinet was not purchased with state funds. Therefore, nothing inside the filing cabinet is responsive or touches on the university's expenditure of state funds. That's the categorical determination. And we're arguing that the categorical determination is not sufficient to meet not sufficient to meet the standard.
But if you're asking for documents about the expenditure of state funds on the cabinet, that's sufficient, right? They're not saying because there are no funds used to state funds used to build the library, then there are no responsive documents. They're saying there were no expenditures of state funds surrounding the Biden documents, and therefore, on its face, given that fact, there are no documents subject to FOIA.
Well, here though, I think if the expenditure of state funds was ever on the table, those relate to the expenditure of state funds, even if in the negative. Even if the gift agreement sets forth how the expenditure of state funds are going to be used, or excuse me, what funds are going to be used. In the negative, they relate to the expenditure of state funds.
So if I understand that, if there was an email where the university president said, are we spending state money on this? And the answer is no. That is a responsive document?
Yes.
And I'm sorry I interrupted you.
Of course.
Did you ever answer the question about what is the standard of proof that you're advocating for here? What standard would meet the burden?
Well, and my choices, I think, are beyond a reasonable doubt, clear and convincing, or preponderance.
Some entirely new standard.
Entirely new standard?
Feel free, yeah. What's the standard?
Oh, okay. The standard is that on the enough information for us to actually some variety of adversary proceeding. I'm into my rebuttal time. Some variety of discovery or otherwise, so that we can test the information and test its veracity. And preponderance of the evidence, I think, will do. But at the same time, in this proceeding, we've had no opportunity to actually test the university's representations.
So you could never get out from under a FOIA request without litigation. There would have to be litigation over the response that there are no responsive documents.
Respectfully, Your Honor, may I? I'm into my rebuttal time. I'll answer that question when I return.
That's fine.
Thank you.
Thank you.
Thank you.
May it please the court. Before responding to the precise points made by my opponent, I think it's important to set the stage of FOIA as it applies to the university, because it's very different. And that begins a little bit with the history, and I'll move quickly. In the mid-'70s, the General Assembly decided that transparency was a good thing and decided that it was going to have a state statute requiring state agencies to produce public records for public inspection and to open up their meetings. And then the General Assembly hit on a very interesting question. What do we do with the University of Delaware? The University of Delaware is privately managed. It has a charter that actually protects its privacy and its autonomy, but it spends state funds. Shouldn't the people of Delaware be able to look at records that demonstrate how the university spends state funds? So the answer was, and it's kind of an elegantly simple solution, the university under FOIA will be treated as a state agency when it's spending state funds. And Your Honors, the court's decision the first time around advised the world, including the parties here, that relating to the expenditure of state funds means that the document in question, the contents, have to disclose to the reader information about the expenditure of state funds. That's what we learned in round one. And so the reach of FOIA is very different depending on whether you're the university or whether you are a state agency. If you're a state agency, every document you have is a public record, and it's disclosable unless you find in the statute a specific exception. The university is the reverse. None of your documents are public records unless they relate to the expenditure of public funds. And when I say public funds, the statute makes clear that we're talking about state funds. So I will conflate those two every once in a while, and I will say relate to the expenditure of state funds. Now let's look at how this works for the university as a matter of practice. Frequently, the request received by the university says nothing about whether the requested records do or do not relate to the expenditure of state funds. The university can't say no, you haven't intoned the magic words expenditure of state funds. The university must read the request as if that qualifier is implicit in it. We want X which relate to the state, to the expenditure, the university's expenditure of state funds. At that point, the university has a variety of options. One of those options is to identify every document in the universe created by the request and inspect them. The problem with that is that might not answer the question. In our briefs, we picked the simplest example of that, the coach's salary. Requester wants to see the coach's employment contract. By the way, that happens all the time. It is, and there will be expenditure of funds discussed in that document. It's called salary. But the question remains, are those state funds? And the contract isn't going to tell you that because neither of the parties are particularly interested in that issue. So the second option is to ask whether, and I'll put this way, whether the documents, the subset of documents that relate to the expenditure of state funds is the empty set, which is the case here. If you determine that the request, and here the request is for communication records, that's a term that you all defined in round one. Communication records relate to the gift of the Biden papers, the custody and curation of the Biden papers, the eventual release of the Biden papers, but they relate to the university's care and custody of the Biden papers. So and then we ask ourselves, were any state funds spent by the university in anything related to the university's receipt, custody, curation, release of the Biden papers? If we know that that's the empty set, if we can determine that there were no state expenditures related in any way to the Biden papers, then we can say, without looking at the document, which in some case wouldn't be informative anyway, even if it discussed the expenditure of funds, you wouldn't know whether it was talking about state funds. We can say, without looking at that document, that there are no responsive documents if you know that no state funds were spent on the university's custody and curation of the Biden documents. Mr. Green imagined documents which discussed, and his words were, how the university's activities will be funded. Sure. But if we know that none of those activities were funded with state dollars, then I don't have to look at the document to know that I have no responsive documents in my possession.
Mr. Manning, if I can just interrupt you for a moment.
Yes.
This court's first opinion in this case seems to say something else, which is, and I'm looking here at pages 10, 12 to 13 of the reported decision, quote, unless it is clear on the face of the request that the demanded records are not subject to FOIA, the public body must search for responsive records. A description of the search and the outcome of the search must be reflected through statements made under oath, such as statements in an affidavit, in order for the public body to satisfy its burden of proof. We note it is not clear on the face of the requests for the agreement or communication records that they are not subject to FOIA, and the university does not contend otherwise. On remand, the university bears the burden to create a record from which the Superior Court can determine whether the university performed an adequate search for responsive documents. And what I think you've just said over the last few minutes and what your brief acknowledges is that you didn't perform a search. So how could this court ever conclude that what you did is consistent with its prior decision?
Your Honor, I read that decision to say as follows. If it's clear on the face of the request upon first reading that there are no responsive documents, you can deny it then. That will rarely, if ever, happen, but I understood what the court meant. We believe, though, that if it becomes clear at any other time, before you've actually looked at the universe of documents, that they couldn't contain information about the university's expenditure of state funds, then in that situation as well, there's no reason to inspect the documents. But what you must do, and what this court required, and the Superior Court required, is demonstrate how it is that you come to that conclusion. How do you know that no state funds were spent by the university on anything related to the Biden papers? And if you do know that, I didn't read the court's opinion as saying, even there, if it becomes clear at a point, perhaps not on the face of the request, but at another point before you've actually looked at documents, and I've explained why sometimes looking at documents doesn't tell you the answer to the question. So if you can say at any time, it's clear, there are no responsive documents, then the university should give that response.
Mr. Manning, isn't it the case, though, that whether it is clear that no state funds were expended in connection with the Biden papers, that fact can change over time? And if that is the case, I find it a bit puzzling why there was no sort of bring down of the inquiries that were made, especially given the pendency of this litigation. It's almost a sort of digging in of the heels. Can you help me out with that?
Yes,
sort of the staleness argument?
Your Honor has asked, I see two questions there. First question is, can you rely on information that you knew to be true, but you knew that to be true, you received that information 4 months ago? Can you rely on that same information if the same question is raised by a current FOIA request? The answer is, unless there's any reason not to rely on it, you can't. Now, if the facts were that years passed between the first requests, and by the way, there were multiple, this was a subject of great interest. And so there were several requests to the university about the Biden papers. And so the university's FOIA coordinator, working with others at the university, had already been down this road. And so your question is, could things change in 4 months? The answer is no, not in a single budget cycle. There's no reason to believe that the source of funds with which the university's activities related to the Biden papers, there is no reason to believe that that would have changed mid-year. And so I would say to you, if years pass between the first inquiry and the now current request, I don't know that the information gained the first time around would be reliable. But I think university officials are entitled to make a judgment whether information gained 4 months earlier was reliable, and they did.
But how does this court know that other than your representation today? If our prior opinion said we need competent, reliable evidence, and they're saying, well, facts and circumstances can change and there's been an intervening time, how do we take comfort that the representations made in May 2019 are still reliable? I mean, wasn't that supposed to be in the supplemental affidavit?
Two questions again. It was not called for by the, we got very specific instructions from the Superior Court in the end, and we met each and every one of those instructions. But more generally, Your Honor, I don't know that that's the response you're looking for. I think if the university is using that as a basis, then implicit in that is the university's judgment that those facts couldn't change in 4 months. And I don't know why we would conclude otherwise. If there's a reason to suggest, if someone has suggested a reason why information gained 4 months before the FOIA request is unreliable, they should say so, but that's never been asserted in this case. So you ask the kind of easy question, well, isn't it possible that things changed? The answer is yes, but then the university, in relying on that 4-month-old information, made a judgment that it's still reliable. The university's burden here, we talked interesting questions about burden of proof. The answer to that question is actually shaped by what the burden of proof relates to. The statute requires that the university has the burden of proof to do what? To justify its denial. So we're not dealing with proof of facts here. We're dealing with facts that add up to a reasonable justification for the denial. And I think the university is entitled to say to itself, those facts haven't changed, wouldn't change in 4 months, and therefore the information I had 4 months ago remains reliable.
So I want to make sure I understand your position, and I understand it to be, if the university was justified at the time of its denial a few years back, it doesn't matter if circumstances change during the pendency of the litigation.
Thank you for reminding me about the second question that I saw in your Honor's question. That's right. Once the denial has occurred, there's no request pending, despite the ongoing litigation that we've seen in this case. And there's no continuing duty to go back again and again and again. The request was denied, and the dispute here is whether that denial was appropriate. And the university's burden is burden of proof. But burden of proof what? Proof to justify its denial. And so the Superior Court has to make that judgment. Does what the university has shown me in this case justify the denial? Have they proved the empty set? I think the answer is yes. And what do my friends say about that? They say, well, this wasn't the personal knowledge of the affiant. We learn in many ways. People gain knowledge in a variety of different ways. One of them is by talking to someone who has expertise. That doesn't mean that it doesn't become the personal knowledge of the affiant. But the appellants want more. You heard talk about depositions in my friend's remarks earlier. They want separate testimony under oath in the form of an affidavit, perhaps at first, but then they want to be able to challenge that witness and depose. All of those things suggest that they believe that the statute calls for an adversary proceeding at which facts are proved up under the rules of our trial courts and with the rules of evidence applying. I will observe, Your Honor, that there are two options facing a disappointed requester. You can, under the same statute, you've seen it, 10005E, and I never know how to say that, and so I'm just going to say it that way. That gives you the right to get a quick answer from the Department of Justice. That statute requires that the Department of Justice review the denial and respond within 20 days about whether the denial was justified. There's another option. You can sue. You can go right to court. You can, depending on the relief you ask for, you're in Court of Chancery or the Superior Court, where you'll get all those things that the appellants are saying were not given in this case. You can't get it both ways. If you want a quick decision, because I submit that fact hearings, the kind of which my opponent suggests are appropriate in this case, you can't get those things in 20 days. And I don't think the General Assembly intended that someone who takes that option, I'll just ask a trusted public official, was this a justifiable denial? And I'm going to get an answer in 20 days, which news organizations want. They often place a premium on speed. That was their option. And it's too late, I think, to complain to this court about hearsay. We define hearsay as assertions made in court where the declarant is not in court. Somebody else is saying what the declarant said, offered to prove the truth of the matter asserted. That's clear. That rule applies in a proceeding, an adversary proceeding designed to prove up facts to a judge or jury. There's no suggestion in the statute that that rule also applies in the administrative proceeding that the appellants chose in which to press their challenge to the university's denial.
Mr. Manning, what is your view of what the court meant in the last opinion by competent evidence? You've just expressed that it doesn't have to be, in your view, admissible evidence under the rules of evidence. What does competent mean?
There's very little guidance, and so I'm going to answer Your Honor's question with what I think it means, having wrestled with this statute. Every time I touch this case, by the way, it's like an onion. I peel away another layer and I reach a new understanding. I think, though, that I can justify my denial with evidence that satisfies you, that evidence that gives no badge of lack of credibility or untrustworthiness. If there's nothing about what I'm telling, in this case, the Deputy Attorney General, that suggests that that information is not reliable, then it is competent in that context, Your Honor.
Thank you.
I don't know how I'm doing on time, but if Your Honors have no more questions, I've concluded my remarks. Thank you very much.
Thank you very much, Mr. Manning. Mr. Green, you have a few minutes remaining.
Thank you, Your Honors. For the first time in this proceeding, I've heard a procedural argument that rather than start with the Attorney General's office, we should have started with the Superior Court, and in which case we'd have had the full panoply of procedural protections and procedural inquiries that we would have that we were denied because we started out, as our understanding of the statute reads, that we were obligated to start with an appeal to the Attorney General's office. The standard is the same in the statute. It's still the university's burden of proof to justify the denial of the request. That issue was not briefed, but if it turns out that's the case, that from the word go, we need to start at the Superior Court, in which case we get depositions, we get actually that would be a new piece of law, and it'd be interesting to hear it. It's a preponderance. It should be a preponderance of the evidence standard. We start with a request. It starts with making a prima facie case for the applicability of the statute to the requested documents, and it's the university's obligation to rebut it, and it's their obligation to rebut it with competent evidence. Under the circumstances and where we are now, we need to probe what steps the university took. We need to probe, there's been a bare minimum of representations as to what they've done, and they've relied on these categorical determinations. Categorical determinations we don't believe are fair and need to be tested through an adversarial process. The gift agreement we believe should be produced. It's the Biden papers are of incredible public interest, and we just need to know if state funds were used and how they were funded. It seems implausible that the gift agreement does not relate to the expenditure of state funds, even in the negative, because it presumably sets forth how the the university pays for the upkeep of the Biden papers.
But, Mr. Green, even if the gift agreement sets forth how the papers are stored and kept, just because it says that, how does that relate to the expenditure of state funds? I heard you say earlier that by dealing with any expenditure of funds, essentially in the negative, that means it relates to the expenditure of state funds. But isn't that a bit circular in the sense that it would then effectively capture any UD document that relates in any way to the expenditure of funds?
Well, under the circumstances, we believe that this is a situation where the gift agreement should be produced because of how it's been 3 years, and we're still at the same place with the same representations, and we have not had an opportunity to test the representations of the university, and it's their burden to prove.
But as to the gift agreement specifically, paragraph 11 of the affidavit, the affiant states that she has on several occasions before and after receipt of your request reviewed the gift agreement, and it does not relate to the expenditure of state funds. Other than your view that that's implausible, she says it's under oath. She's a member of this bar. Why should the Superior Court of this court not take her at her word?
Well, we would like a statement as to whether it addresses the expenditure of funds. We'd like, and what the sources of those funds are. The gift agreement, this is my time's running down, but this is a colossally important gift of a significant public interest to the public.
Thank you very much. We will take the matter under advisement.
Please rise.